For the court here today is Mr. Kevin Stapleton. He's the agent from the Department of Corrections, serving as the probation officer on this file. Also before the court is the defendant, Mr. William Forrest Manicky. Is that you, sir?
Yes, sir.
All right. Mr. Manicky, I'm going to tell you what the allegations are. You were here today for what's called a show cause on a request and summons versus a warrant that didn't have you arrested. A request and summons for a probation violation. I need to tell you what those allegations are, what your rights are, the possible consequences, and then see how you wish to respond. Count one alleges you violated condition 4.4 of your terms and conditions of probation. That term requires that you must be in your approved residence between the hours of 10 p.m. and 6 a.m. And more specifically, it's alleged that on or about July 7th of 2026, you were not in your approved residence between those hours. Count two alleges that you must not use or possess alcoholic beverages or other intoxicants. And more specifically, it's alleged that on or about that same date, January 7th of 2026, you consumed alcohol. Count three alleges a violation of condition one. That condition requires that you are not to violate any criminal law of any unit of government. And more specifically, that on or about January 7th of 2026, you committed disorderly conduct. You have the right to challenge these three allegations at a contested hearing. At that contested hearing, the prosecutor have the burden of proof by what's called the preponderance of the evidence, which is a standard lower than at a criminal trial, where the proof is, or the burden of proof is beyond a reasonable doubt. You also have the right to be represented by an attorney at that hearing and all subsequent proceedings regarding these alleged violations. If you cannot afford your own attorney, the court can have one appointed to assist you. Now, at that hearing that I mentioned, you have the right to review the evidence presented against you, question, cross-examine any witnesses presented against you, or to present witnesses, evidence, or testimony, or remain silent and not have that silence used against you. Do you understand those rights? Now, if you're found to be in violation of your probation, you will be resentenced on your original offense.
So if I
Okay, just a second. Let me find it. Mr. Stapleton, what I'm looking for is, yes. All right, this is the unlawful use. Is this a 2-year or was this a first offense? Because
this is a 2-year, Your Honor.
all right, thank you. All right, there I see it. If you're found to be in violation of your probation, you will be resentenced on your original offense. You were originally charged with unlawful driving away of a motor vehicle, but you were found guilty of unlawful use of a motor vehicle as a high court misdemeanor, punishable by up to 2 years and or up to $2,000. Now, because in this particular file, you've got 3 allegations, as I mentioned. Counts 3. 1 and 2 are what are called technical violations. For technical violations, the court is limited to a sliding scale, 15 days for 1, 30 days for 2. And you have a third violation. That third violation is an allegation of violating a law. That one is a non-technical, and the court is no longer limited to a sliding scale, which means I'm only limited by the amount allowed under the law by the original offense. Now that I've told you what the 3 allegations are, what your rights are, and your possible consequences, I need to see how do you wish to respond. Now let me explain. I know this is where you're going to go, so bear with me. Number 1, you can, if you choose, waive your right to have an attorney and plead guilty, and then we proceed to sentencing. There's no agreement. Hold on. All right. If you do that, I don't. There's no promise about what's going to happen, and I don't tell you ahead of time what I'm going to do. Number 2, you can choose to request appointment of an attorney, or tell me that you're going to hire your own attorney. If you do that, we'll then have it set for an informal hearing. That informal hearing would most likely take place next week. I'll release you back out on bond since you came here today. There wouldn't be financial bond, it would just be on your own personal recognizance. And you'd come here next week and we'd have a little hearing where you would appear with an attorney and the prosecutor, and you guys would tell me what you're going to do. You would either plead guilty to 1, 2, 3 charges. The charges would be dismissed by the prosecutor. I don't know. Or the next thing is it would be set for a formal hearing where the prosecutor would produce some kind of evidence. That could be from witnesses, it could be from police reports, it could be from a variety of sources. The hearings on probation violations generally take about 15 to 30 minutes. So if you want an informal hearing where you get an attorney and you guys come back and negotiate, I want a not guilty plea, have it set for sometime next week. And then if we appear next week and you say, I ain't pleading guilty, gosh darn it, I want my contested hearing. I don't care. Then I set it for a contested hearing. That contested hearing must be conducted within 14 days from today's date, unless you and the prosecutor waive that 14 days and bump the case out. So do you have any other charges pending in the district court?
No, I think everything that you mentioned is the only thing I have going on, so.
Okay, well, let me explain that. That third count, disorderly conduct, could result in a charge, and that would be a misdemeanor, would be handled in front of Judge Wiggins. Have you appeared in front of Judge Wiggins in the last month?
I have not, but I had a court date settled in Isabella County, in Mount Pleasant, on the
Okay.
27th, and I went there and they had postponed it, but I made a payment on my fines, and
All right. So
I have upcoming court date.
So now I understand.
Isabella County.
Hold on. So now I understand. That tells me or suggests to me that you have, that these allegations, don't say yes or no, because then that would be an admission. The allegations involve something in Isabella County and not in Wexford. Therefore, if it was Isabella, based upon what you said, charged you with disorderly person, you may have gone for a court date, but if you have another court date, that tells me that that charge is still, or that case is still pending. I don't need to know everything about it right now. So let's go back. Do you wish to have the court appoint an attorney to assist you?
I do, I don't want to say too much. So.
I don't care. No worries. No worries. All right. Paperwork. Here we go. This court enters a no contest plea for the defendant based, I'm sorry, not a no contest, a not guilty plea on behalf of the defendant based upon his request for appointment of counsel. The court recognizes that the defendant had prior appointed counsel. Therefore, this case will be referred to the Wexford Misaki Public Defender Program for the appointment of an attorney. I'll note that last time you had counsel James Dick, who I do not believe is taking any more cases in Wexford County. But if he is, then they will appoint him. But anyways, you should hear from an attorney within the next couple of days. Mr. Manicky, are you still at the address on 7 Mile Road in Everett?
No, I'm not. I'm at 501 Hemlock, Clare, Michigan.
Oh, wait, that was on the most recent paperwork. I'm looking at. All right, I see that. The 501 Hemlock, you said?
Yes, sir.
Yeah, the other one was on an older document. And is your cell phone the one that still ends in 1272?
Yes, sir. Yes, sir.
Okay. Gotten a new cell phone in the last year?
I have not.
It should be the
Sir,
same.
yes, I did. Yes, I did.
All
It
right.
says 253-1272.
All right.
That's my number.
We'll have the matter set. I just needed to make sure I had those phone numbers and addresses correct so your attorney can get a hold of you. The court hereby releases you on your own personal recognizance. You're still on terms and conditions of probation with Mr. Stapleton. Thank you. We are adjourned.
Okay, thank you. Have a good day.
You too, sir.